services. Para español, marque 9.
Fortunately, I'm not sure. Are you going to send me a letter for each document that is that's subsequent to? I mean, I'm not even sure what was sent on the 6th.
That's the response letter itself.
Okay, and so all the discriminatory acts that I sent after that, or in or on that, or whatever, you're just to consider them not as happening, or what, how?
No, but this is our response. This is our response in total to your civil rights complaint.
Okay, that's your response. So, can we go through each one of the documents and have you verbally tell me that that's not discriminatory on each and every example?
No, we won't go through each of the documents, but you do have a right to appeal, as we put in the letter there.
Right, but you understand, I can't always. Can we go through each one of the documents and have you verbally tell me that that's not discriminatory on each and every example?
No, we won't go through each of the documents, but you do have a right to appeal, as we put in the letter there.
Always be appealing for my civil rights. That's not how the law is supposed to work. You're supposed to be able to readily identify discrimination and prevent it from occurring. But you're telling me that you can't even find it even when it's presented to you. Don't you think that's problematic?
That's our finding. That's our finding, and your right to appeal and your options.
Right. Also, I do want to clarify one thing, that there's that the letter that you sent me that I just read is full of logical fallacies, and all it does is outline a history of the events and doesn't really address any of my concerns regarding my civil rights. Do you understand that? You allege this happened, and then we found out that it didn't happen. Where are those statements? Can you tell me that?
So if you choose to appeal,
no. There's no appeal, dude. I don't right now. This has happened. You can't pretend that it didn't. You have an obligation as an employee to do this, regardless of whether or not I appeal or not. Why don't you understand your obligations?
So that is our response, and your appeal rights are in that letter.
So you don't have any other rights to protect my rights other than you just saying that our response is in that letter.
So yes, you filed a civil rights complaint, and we responded formally in writing with your options.
Right, but you didn't address any of my complaint. So you're saying I have to appeal because you won't address the complaint. And so who do I actually have to stop appealing to? Why? So you guys can just play dumb while you steal my son and then make me pay you money for it? Just play dumb while you steal my son and then make me pay you money for it? So you understand that's what you're doing, right? That's a Nazi propaganda type thing.
Okay. So again, your options for appealing this response.
Okay, so you're saying that you can't identify anything wrong with any of the paperwork that I sent you. Everything's on the up and up.
This is our response to the paperwork that you sent us, correct?
Everything, all of it, even including up until today. You couldn't find any discrimination.
Correct.
Okay, you stick with that. And so I'll just have to file the appeal, and then I hope that they can look at it and says you're not entitled to anything, and say, oh yeah, that's definitely discriminatory.
Understood.
Or here, what about can I have a recess? No, we already approved that you can have it, but you can't have it now because I'm pissed off. I mean, what is it that what can you identify as far as this? So, yeah, maybe you can explain to me what you feel is discriminatory and not just what is it that I have to show to your team over there that is discrimination that you will make an action.
So you have our response and what our findings.
Right. No, I get that.
You can make those arguments.
You keep giving me this logical fallacy of that because you just enforce an order or you don't actually address any of the situations that have come your way. It's like in your letter, there's no response to any of the acts that I commit that I allege are discriminatory.
Then you can make that argument in your appeal.
Why do I have to appeal something that you already know? I mean, what? Oh my God. you're telling me to appeal something you haven't even considered.
So again, this is our response. So if you want to appeal it, if you don't agree with it, you definitely have the right to appeal it, and your options are in that letter.
So now I've got to go to the Department of Health and Human Services and hope that they'll acknowledge that you guys are all liars. I mean, what at what point can we just say, yeah, that's a lie, that's a lie, that's a lie? They're in trouble, or oh no, we didn't, some logical fallacy, and then that's our response. We don't have to address your concerns because that's our response. We don't have to acknowledge that they discriminated against you to get this order, and so therefore they're enforcing an order that's not really valid because they discriminated and violated your due process to a fair trial. But we're just going to say that didn't happen, not based on any particular thing other than we just sent you a letter saying that it didn't, right?
So you can make those arguments in your appeal if you choose to appeal our response.
Right. No, but I made those arguments prior to you making your decision, dude. You're acting like you didn't know this information, but you did.
No, our letter is in response to all of the information you provided to our office.
Right, and you know that information indicates discrimination, retaliation, and abuse.
No, I'm not in agreement with that as stated in our letter.
It doesn't state anything in the letter other than the timeline of the events that occurred.
No, above the paragraph right above your right to appeal, it summarizes, with the information given, we have found no basis for the allegation that you were subject to discriminatory treatment based on membership in any protected class.
You were not hold on, let me look at it again. Hold on.
Sure.
Let me open this up. Here it is. Where? Okay. Yeah, I don't know why it didn't jump there. Okay, so I thought that was something else, but that doesn't matter. I'm just surprised that you would make such a claim. But okay, so federal law states that the local child agency may not discriminate against a person.
Yeah, so the paragraph I'm referring to is on page 2. It's the paragraph right above right to appeal. The paragraph right above where it says right to appeal.
Okay, Orange County are dedicated to fair and with the information given, we have found no basis for the allegation that you were subject to discriminatory treatment based on membership in any protected class. The actions taken were applied consistently to your case as they would have been applied to any other similar case. The findings of this investigation do not support your claim that your civil rights were violated. Okay, so I guess that's erroneous in nature, but so where is the examples that do violate your civil rights?
So again, Mr. Option now that you have our written response with our findings, is if you want to disagree with it or challenge it, you can appeal it.
Jesus Christ, man. So have you ever found discrimination occurring from a judge ordered?
I'm not going to answer that. I'm talking about your specific case.
Right. But I need to know whether or not my rights are actually protected. And if you tell me that you've never found discrimination in any of these cases, I know that you're full of crap, right?
I'm not going to address other cases. I'm going to address your case.
Okay. And so because you made this statement here, that's had to have what happened. Or no, you have the right to appeal that. Just like I had the right to appeal it to you, and then I get the right to appeal it to the next person and then the next person. But so nobody really ever has to acknowledge that there was abuse? Is that what you're doing?
No, your escalation right is in the right to appeal. So the next level, if you choose to escalate this, is to either the U.S. Department of Health and Human Services,
right? And have we? But before we even do that, have we avoided the trap of who actually is responsible for? Because I guess that's one way of forcing this issue without an appeal. Is it your main? Are you asserting that the courts are responsible for any modifications going forward to my child support?
I don't understand this question.
Okay, so
If you want your child support modified, then one of your options, yes, if you choose, is to file a motion with the court. I don't know if that was your question.
okay, so that I've tried to do that, and they've said that and we've gone over this. I mean, now you're playing dumb again. This is very concerning. I've gone to the court, and they said no. The jurisdiction to change your child support is with DCSS. I've come to you, and you've said to me, no, I've got to go to court to get it changed. Now once I play those tapes for you, you can't say that it didn't occur, nor can you say that my civil rights were not violated, because that is a violation of one's civil rights. You can't say that this person, and I've already written this out. Why are you playing dumb?
No, I'm not.
Why are you playing dumb?
No, I'm not. When there's a case open with our office and a customer wants a child support modification, they can either request a review through our office or they can file their own motion directly with the court. I believe, and correct me if I'm wrong, the situation you're explaining is you were in one of the courtrooms that doesn't handle child support services cases. So maybe that commissioner was referring you to the child support courtrooms that handle child support case modifications. Is that possibly what happened there?
No, what's possibly happened is I've been kept away from that court so that I can't get the modification that's necessary so you guys can receive enough money to pay your friggin' bills. I mean,
I saw one of your emails was to Robert Bullock, and you requested that he file a motion for you, correct?
yes, and he didn't do it.
Okay, well that's the thing you would address.
He hasn't sent me any of the information that I told you two or three times and all the stuff before, and you say that's not discriminatory. Don't you see that's very concerning?
Okay, so again, you have
that's my right to appeal. So you were told whatever, under no circumstance are you to find discriminatory action, nor are you to tell him what actually you think would be discriminatory. So there's no way of you actually being in the wrong. Is that what you're describing to me?
No, you have our formal written response with our findings.
Right. And so then you back yourself into that. That's your protective shield. I've given you a letter, so therefore I couldn't have done anything wrong.
Well, it's a letter with our findings.
Right. Yeah. You found what you wanted to find. You didn't actually look at the evidence that actually indicates what it is that I've told you occurred, and we know that occurred, and we know that by definition those are discriminatory acts. You just sent me a letter saying some bullshit saying about we didn't find anything.
Oh, well, and you can appeal it.
You can appeal.
The response.
I have to keep appealing that each one of you is not a moron? I mean, why is that necessary? Do you not know what? How about you tell me the definition of discrimination?
Okay, I'm going to end this conversation.
Because I'm asking you what the definition of discrimination is?
You have our formal written response. It gives you your appeal rights. And I'm ending this conversation. Have a good day.